Hi distinction students, civic education students. So welcome to civic education online lessons with Knowledge World Academy. The perfect tutor here, Mr. Gilbert CJ. So we are still looking at family law, and in our video for today we are going to focus on divorce. These are the elements of family law. So in the previous video we only looked at marriage as an element of family law. So now we'll look at divorce, property settlement, maintenance of spouse and children, adoption of children, and inheritance of property. This is where we are going to find the testate and intestate succession. Okay, so without wasting much of your time, let us start. We are going to start with divorce. What is divorce? This is very familiar to you. So divorce refers to the state of breaking the marriage irretrievably. So under the law, marriage cannot be considered for divorce until the court handling the case is satisfied that a marriage had actually existed. So when you petition for divorce in the courts of law, the court will not just go directly into handling the case of divorce that you have presented before it. It is first of all going to determine whether the marriage had actually existed between the two of you. Does your marriage have a legal standing order? These are the things that the court is going to determine or prove before they handle the case of divorce. So as we learned in the previous video that we have two types of marriages. We have customary marriage and civil marriage. So we are going to look at divorce under customary marriage or customary law, and divorce under statutory law or marriage. So according to the Matrimonial Causes Act of 1973, divorce under a customary law will take place depending on the custom the couple was married under. You may agree with me that different tribes in Zambia have got different traditions and customs that they carry out during marriage. So your tradition or your custom which you used when marrying each other will determine the divorce, or it is the one that you are going to follow when divorcing as well. So some of the payments may be returned to the husband's family, and it is expected under the customary law that it is the man who divorces the wife and not vice versa. So some of the payments may be returned back to the husband's family, the one who paid. Especially lobola, they return it back to show that there is no marriage between these two. Okay, now let us talk about the acceptable grounds of divorce in customary marriage. What are some of the factors that can lead to divorce under customary marriage? So the first one is adultery of the wife. Adultery of the wife, which does not need to be proved. So you will understand this when we look at divorce under civil marriage. So for customary marriage, adultery of the wife, though it is not proved, there is no problem. It can lead to divorce. Then 2, cruelty. Always beating up your wife, always beating up your husband. This can lead to divorce. Laziness on the part of the wife, especially the mothers of the husbands. They don't like lazy in-laws. If your wife is lazy and your mother is talkative, I'm telling you, that is positive and positive. In fact, positive, negative. Okay, so laziness on the part of the wife. Then bad relations with the in-laws, infertility, lack of maintenance by the man, desertion. So these are some of the factors that can lead to divorce under customary marriage. Now let us talk about divorce under statutory marriage. So according to the Matrimonial Causes Act of 1973, so this is an act that talks about marriages, there is only one ground for divorce under statutory marriage, which is that the marriage has broken down irretrievably. So in the exam they may ask you the meaning of this phrase, marriage has broken down irretrievably. What is the meaning of this? This means that the marriage cannot be saved or redeemed using any other means. The two parties cannot agree. The two parties cannot get along anymore. So marriage has broken down irretrievably. So grounds for divorce in civil marriage. So understand this one clearly. I've said there is only one ground of divorce under statutory marriage, which is the marriage broken down irretrievably, which can be caused by 1. Adultery, which should be proved with the third person known and named. So, like I said, for customary marriage, adultery by the wife, even if it's not proved, it can lead to divorce. But under statutory marriage, adultery should be proved with the third person known and named, that I found them, I have got evidence that this happened. One or both of the married persons conduct themselves in unreasonable behavior, cruelty, or violence that makes it impossible for the other partner to live safely. So now listen. If one partner deserts another for a period of 2 years, then there is sufficient ground for divorce. So desertion also here is a ground for divorce if it happens for a period of 2 years. Okay. Separation with consent of the couple for 2 years. You're on separation for 2 years. When you go to court, divorce is valid there. It can happen. It's very possible. Living apart for a continuous period of 5 years. Note that a petition for divorce can only be filed in the High Court after 1 year of marriage. So it's only after 1 year of marriage that you can file or petition for divorce in the High Court. Before 1 year, if you want to terminate your marriage contract before 1 year, it will not be a divorce, but that will be called an annulment. The lawyers handling the case should verify whether they try to reconcile the couple during the period of separation. Not just go straight for divorce. Did the lawyers try to reconcile the couple before they file for divorce? A decree nisi is a temporary divorce certificate given to a couple. So first of all, they'll give you a decree nisi as a couple, temporary divorce certificate. Then after 6 weeks, the High Court will give you a decree absolute. This one is a permanent divorce certificate. Permanent divorce certificate, and the arrangements will be made for the children, property settlement and other things. So now let us look at property settlement. This is the second element of family law. So after a divorce in a customary marriage, the woman usually gets some form of compensation to allow her to start life afresh, except in cases where she has committed adultery. So this is under customary marriage. Usually the woman gets some form of compensation. They will be given some of the goods and monies so that they can start their life afresh. But in case they commit adultery, there is no compensation that is given. However, these days it is recognized that whoever is at fault compensates the other. Therefore, whoever has more money will pay compensation to the other. That's how it is these days now. So civic education keeps on changing, so make sure you are up to date. In civil marriage, property is shared by the court's deputy registrar. In a situation where one person worked and brought in all the earnings, the person who stayed at home and looked after the home and family gets a third of the total wealth of the couple. If both worked and earned a living, they will share their property 50-50. 50-50, half. But if you are just a wife, you only remained at home looking after the children, the house and other things, you just get a third of the total wealth here. This is how it is. Sometimes in a civil marriage, a couple may choose to marry in a community of property. What does this mean? This means that everything they owned and their debts from before their marriage is put together in a joint state. They will put everything together. That is marrying in a community of property. Maintenance of spouse and children. So these people have divorced. Now we are looking at Maintenance of spouse and children. During marriage under statutory law, the spouse has a duty to maintain his or her partner. So if you are married, you've got the duty to maintain your partner. Now, after divorce, a spouse still has the responsibility of maintaining his or her spouse until he or she demands or becomes financially independent. So even if you divorce, if you are a husband and your wife is not yet independent, you are a wife and your husband is not yet independent. By independent, we're talking about being financially independent here. Is that person able to look after him or herself? So if not, then as a spouse, you are still having the responsibility of maintaining that partner, even if you have divorced. This is under statutory law. So it may be that you have divorced with your husband or your wife and you are not independent. That person is not even supporting you. You can go to high court and that person will have a prima facie or a case to answer. Maintenance may be paid periodically as agreed upon by the parties, or it may be paid as a lump sum. They may be paying maybe per month or just at once. They give you maybe 150,000, just like that. The amount depends on the income earned and the financial status of the parties involved under the customary law. They can't say you'll be giving your partner 5,000 per month. Meanwhile, you get 3,000 as your salary. So that's not possible. They will look at your income. Now, that is maintenance of spouse. So you've got the duty to look after your spouse or to maintain your spouse inside and outside marriage until your spouse becomes financially independent. Now let us look at the maintenance of children. The maintenance of children is provided in the Affiliation and Maintenance Provisions Act, Cap 64 of the Revised Laws of Zambia. The Act permits children born out of wedlock, this is out of marriage, to be affiliated to their male parent and thereby claim maintenance. So even if children were not born inside the marriage, they are entitled to claim maintenance from their male parent. So who can claim maintenance? One, a child from its affiliated father or legal parent. Child can claim maintenance. Or a guardian, whoever is looking after that child. For example, a grandparent or an uncle can claim maintenance on behalf of the child. A single woman from the affiliated father or her child. A spouse, whether his or her partner were divorced or not. So a spouse can also claim maintenance. A spouse, we mean a wife or a husband. Note that anyone wishing to claim maintenance can approach the clerk at the nearest local court or lawyer. Now, custody of children. Where should the children live after divorce? So the law states that there should be always an adult to look after the children. If the children are young, the court usually gives custody to the mother. As a mother, you go with the children. If a mother does not manage to provide for the children, the father still has a maintaining for the mother and children. The father still has a duty of maintaining the mother and the children because the mother is unable to take care of them. That is how it is. Adoption of children. These are very short, the elements of family law. So custody of children is done here, just like that. Then adoption of children. The Laws of Zambia and Adoption of Children Act, Chapter 136 of 1948, the courts have been giving power to grant an order to adults requesting to adopt a child. So if you're unable to have a child by yourselves as a couple, you can adopt. So categories of adoption. A couple can jointly adopt an infant. So who is an infant? An infant is a child who is less than 7 years old. So you can adopt as a couple. The stepmother or father of the infant is also eligible. Stepmother, like the child is not your biological child, so you can adopt. Both the infant and the person applying for adoption should live in Zambia. The infancy has been looked after by the applicant continuously for at least 3 months before the date of adoption. You should look at the infancy. Say, oh, is this person or is this child below 7 years? The person intending to adopt should notify the commission 3 months before adopting. So these are some of the points, the factors that you must consider as you are adopting. So it is not bad, it is okay. Now, there are some things that the law forbids in case of adoption. The law forbids adoption if 1. Adoption of a female infant by a male applicant on his own, unless there are special reasons for doing so. As a male, you just want to adopt a female infant. You know that's dangerous. So the law forbids that. Adoption of an infant who already has parents or guardian or anybody providing maintenance. You don't adopt such people. So when granted the adoption, you should be registered by the registrar who records the details in the Adoption Children Register. Adoption of Children's Register. This is how it is under adoption of children. Inheritance of property. So in Zambia, the inheritance of property is provided for in the Testate and Intestate Succession Act. We have 2 acts that guides the inheritance or sharing of property. So testate succession. So this one deals with the inheritance of property of a dead person who left a will. What is a will? A will is a declaration normally in writing stating how a person wants his or her property to be distributed in the event of his or her death. So you will write a will. Okay, when I die, the money that is in the account should be for Mulenga. The vehicle is for Chanda. The farm or the land is for the firstborn child. Like that, you write a will. So when you die, the people will use that will to distribute your property. So if you die and you have left a will, what will be used when distributing your property is the testate succession. But if you die without leaving a will, it is the Intestate Succession Act that will be used. So I hope you are able to get the difference here. So key terms in the Testate Succession Act. Testator. So testator is a male person who made the will or the deceased. Now this is a male. Then a female is known as a testatrix. Testatrix. That person who made the will. Then an oral will can also be valid if it is made in the presence of 2 witnesses, not beneficiaries to the estate. Maybe the deceased did not write a will, but some people heard him saying, oh, my land is for my last born child. The last born child shouldn't be the one presenting the will, no. Other people who are not even beneficiaries to the estate should present that will, an oral will, like just a spoken will. That is how it is. Then intestate succession. This one I've explained it. I've said this is the act that is used to distribute someone's property who dies without leaving a will. Then property is defined as a person's items of clothing, articles of personal use such as vehicles, bicycles, furniture, appliances, utensils, boat, livestock, agricultural equipment, books, money, and others. These are also called property, not properties. It's property. So let us look at the intestate succession. The testate succession is very simple because as the deceased, you wrote everything. So they will just follow what you said. Oh, land is for Chite. Oh, land is for Mwansa. Okay, Mwansa, land is yours. The vehicle is for the wife. Okay, the wife, the vehicle is yours. This is what. Here, the deceased died without leaving a will. The deceased died without leaving a will. So now, how are the things going to be shared? How are the property going to be shared? So, 50% goes to the children. We have 100%. 50% goes to the children. If there are no children, 50% goes to the spouse, the surviving spouse. 20% goes to the surviving spouse. 20% goes to the parents of the deceased. then 10% goes to the dependents of the deceased. So the deceased is the person who has died here. So in case there are no children, the deceased left no children, the 50% will be given to the surviving spouse. If there are no parents, the 20% will be given to the children, not the spouse. The 20% will be given to the children. If there are no dependents, the 10% will be given to the children. If there are no dependents, the 10% will be given to the children, and they will have 60%. But if there is no spouse, 20% will be for the parents. So I hope you are able to get this. 50% goes to the children, 20% the surviving spouse, 20% the deceased, and 10% goes to the dependents of the deceased. So this is very important for you. You have to know. In case you die without leaving a will, just know that this is how your property is going to be shared.